back. Chuck Cook, the handsome Aaron Hall, and Greg Siskin, who's also handsome in his own special way.
My own weird
way. Somebody commented to me on Twitter, "Where have you been? It's been 2 weeks." No, come on, I took a vacation.
I was having a life.
I took a vacation. Because I hadn't taken a vacation in a year and a half. Since COVID. Who's taken a vacation since COVID started? So we were celebrating our 37th wedding anniversary in Peru. It was awesome. We were just talking about Peru. We all love the place. It's awesome. You should go. It's a great country. Don't want to necessarily live there. They elected a communist. Probably not the best thing in the world for them to do. So guys, we have a couple things popped up this week. I better get into, I don't want to get Lily to be tweeting at me directly for not putting stuff up. But the first thing I wanted to talk about was the H litigation. If I can find it here. The lottery abuse case. This just popped up out of the blue because immigration decided to do a third lottery, which they told us they weren't going to do, which they told a federal court judge they were not going to do. That I was just stunned by that. I mean, really. Because they had to know, they told a federal court judge that, right? That they didn't alert the judge in advance. Hey, judge, here's an updated affidavit to explain why we lied to you before. But no, they didn't. It's like they just ignored that. And I mean, hopefully Judge McFadden doesn't take that lying down. But here's what I think was interesting. One of our plaintiffs is a brilliant economist, near as I can tell, because he gave us some really interesting stuff, didn't he, Aaron? That it appears that the no-file rate, not the denial rate, because the denial rate, Greg, is like really low this year. Isn't it like 5%? Super low. So that means the no-file rate has got to be astronomical. And, I hate to tell you I told you so to these guys, but we told them that this was going to happen, didn't we?
What do you attribute that to, Chuck?
Duplicate applications. I mean, there's clearly a massive amount of fraud going on. And who's going to file 4 different applications once they get picked in the lottery? Just go. If there's a 95% approval rate, you're just going to go with one application, one employer at that point. And they clearly didn't believe us when I did as they geared up quickly to do the second, now the third one, because they wouldn't have had to. Of course, they only picked 85,000 in the first lottery. So there was a guarantee they were going to do a second lottery. But the second lottery was 27,000, if I recall correctly, which would have put them at 130,000 for 85,000 slots. Even at a 30% denial rate, that would have been enough. But now with a 10% denial rate, the only explanation is duplicate filing. Now they will say, well, people probably just didn't do their, they decided to not do the job anymore. In this economy, no. The sad part about that is we have plaintiffs that abandoned the United States that went to Canada because they needed to stay in status. They needed to get something filed. And you can't tell me that CIS didn't know in September that they were going to have to do a third lottery. They absolutely knew that. They had to have known that because they didn't just pick, we're short 300 people. They picked 16,000 more people. I mean, it doesn't make any sense. It doesn't logistically, numerically, it makes no sense. And one of our plaintiffs, he said they're going to have a 4th lottery. He's convinced there's a 4th lottery. So maybe the judge will decide the motion to dismiss at this point. We'll see. I think we need to maybe figure out a way we can get Judge. I guess we should have gotten his attention. We both made filings, right? But shout out to Waleed for doing a great job on that filing while I was and Emily while I was in Peru. All right, so we did that. We do have the other piece of news is on our EAD litigation. You want to give us an update on that, Aaron?
Sure. Well, let's take it back a step and remember that we filed this case on the 8th. And the 2 categories that were included in our filings were the AOS applicants and the E2 spouses. Shortly after that, we had great news that there was a settlement in another case, which where the government basically agreed, and Chuck might take issue with the way I phrase it, but they basically agreed that the E2 spouses are employment authorized incident to status. Now, what they said in the agreement is our previous interpretation was reasonable and it was fine, but we're also allowed to interpret it this other way. Whereas we would probably phrase it, you must, the statute says you have to interpret it this way. So anyway, after that, we have been accepting new plaintiffs who wanted to sign on. We have a number of people who are going to become named plaintiffs. The amended complaint is drafted and going through review right now. Our expectation is that it's likely to be filed today, if not today, then tomorrow. And then we will be waiting for the government to either file an answer or to approach us and say, hey, let's negotiate. And so we'll see where that goes.
So what we're going to do is we've served the government. The government has been served in the case. They have not entered an appearance in the case. It is a class action. So the named plaintiffs, of course, will be the representatives of the classes. And Aaron, we are expanding the classes, aren't we, besides from EAD spouses and adjustment applicants? Or did we not get anybody beyond those classes?
All of our people who are coming in are in the same category. They're the adjustment applicants.
Yeah, because they're taking a year to do adjustment EADs, which is a great article today by Catherine Rampell of the Washington Post. A terrific article about this exact issue and the consequences of USCIS literally just failing to do its job completely. So we're going to file that. If you have a different EAD, if you have an EAD based on whatever, it could be asylum, although there's a brand new class action just filed on asylum EADs. But if you got something else, we're happy to stick it in there because
J2 spouses,
J2 spouses,
categories that other than the ones that are in there that could be in there if we get.
But we're not giving up on the E2s because frankly, that quote settlement it's a joke. It's into status, but we still got to do stuff for you. When are you going to do that exactly? And by the way, it's only good until your status. Well, of course, it's only good till your status expired. But if you're not going to adjudicate the E2 extension fast enough, whose fault is that? So there's a whole lot of stuff that I still strongly disagree with on that settlement. But and they're clearly under nothing other than a reasonable time frame to work stuff out with CBP to get I-94 cards updated.
We also so there's been a little bit of a back and forth regarding the H4s in this case as well on there, and I think at the end we decided not to include the H4s largely because there's a different case that is litigating the same issue. Ayla is co-counsel in that case, and it didn't make sense to have two cases litigating the same issue with the same co-counsel.
And the same class, they're seeking class certification there.
Yeah, so the H4s, the good news is that if you're, and I think a couple of people actually paid to be in the suit and they'll get refunded, but you're going to be, your issue is going to be dealt with in that other case. And if they're successful, you'll be able to participate in that one because you'll be a class member.
Now, there's another piece of litigation that we want to talk about today, guys. The visa fee litigation.
Are we ready to talk about that?
I don't know. Are we close?
I mean,
well,
we'll have this case onboarding probably as early as potentially tomorrow, or the day after, maybe Thanksgiving. I'm ready to talk about it. We have been kind of keeping it close to the vest, but I think we're about ready. I mean, we're going to file this case pretty quickly, I think, aren't we?
Yes, we are.
I think we can say in broad terms that there's an issue here that the Department of State charges these fees for the issuance of visas. And for big groups of people, they never did the service that they charged the fees for. So they, for example, for the people who were illegally found not to be eligible for a visa under the 212F bans, they charged the fee, people paid the fee, and then they never got anywhere close to the service that they had paid for. And the basic issue is that the Department of State has raked in all this money without providing the service that people paid for.
Right.
And
so and also CVIS fees for J1s and F1s had to be paid in advance before they can even apply for the visa. And then the State Department was taking the position that they weren't going to issue visas for these people at all based on 212F, the illegal reading of it. So that whole group of, that grouping of fees as well is suspect as far as whether those fees should have ever been collected, knowing that they weren't going to be adjudicating the visa applications for these people. Anyway, we're going to be litigating that and trying to get people their money back. This is the first time that we are seeking monetary compensation for plaintiffs in one of our mass actions. And also, we are not going to be charging any fee to be in the case because we hope to be compensated based on getting a contingency fee as opposed to having the plaintiffs having to actually pay for the litigation. So it will be different, and I think this will affect potentially a very large number of people. So we will be pursuing class certification in this case as well, and something different for us as well as we'll be litigating in a different court.
Let's not talk about which court yet, but it's a special court, and we'll be litigating with a very dear friend of ours, Brent Renison, who's a terrific lawyer. We'll have to invite him on our channel here for a bit about this, but it is
so more to come on that, and we will we'll announce it on social media when we're starting when we're onboarding on that. But we will be filing very quickly in this case, and because it's a class case, it shouldn't matter that much. We just have to get to a minimum number of plaintiffs in order to be able to file the case.
I did want to touch briefly on DV 2022. Because it's I've been looking at a lot of emails, and the Department of State has just announced that supposedly they are giving individual consulates the right to decide cases in whatever way they want to decide cases, which, as I recall, is actually what the law has been all along. And the illegal, what do we call it? With the prioritization plan, which Judge Maida found to be baseless and without valid legal standing, is now supposedly gone. And that means that DV 2024, 2022, people are not level 4 anymore, right? Because DV was considered level 4. I was trying to look here at the monthly visa statistics, and we still don't have any October numbers. It's almost the end of November, and we have no October numbers from the Department of State as to how many DVs they issued. I don't know how hard it is to count to one, but this is a problem for folk because they've now burned through, it appears to be 2 months of the fiscal year, and they have not done 12,000, 6,000, 8,000 visas. They appear to have done basically none. Now, if the prioritization system is gone, the question then becomes, can you sue them just because they didn't do their job appropriately? And can you recover visas from that? And the answer to that is, I don't know. It's a very different animal now that they've gotten rid of their prioritization plan, which they knew that, because we told them we were going to sue them over it, right? So we knew that, that's why they took it away. They didn't want to get sued. They're going to lose. So we don't know if there's a lawsuit in January. That's why we didn't want to get anybody's hopes up. We just said, let's look at the first 3 months and then let's look at the lay of the land. So, but for all you DV 2020 people, again, if you need to get online, do your DS-260, and don't wait for the document email. Send the documents affirmatively to the KCC. So don't be slow, and don't come to me later saying, "Oh, we didn't get the email." Don't wait for the email. Send your documents in. But the visa bulletin is not moving the dates very fast, is it? Let me take a look here at the visa bulletin for this month. You guys taking a gander at that yet or not for December? I did
Well,
know.
EB2 moved.
Yeah. Well, I don't know if you noticed, by the way, but Mexico has reached the year 2000 in family cases. That's amazing to me.
Yeah, how long is it going to take to get past May 1st, 2001?
Yeah, that snake swallowing the pig, because that's about to happen. Yeah, Mexico is looking at those Mexico dates for they're at January 1, 2001. So we'll for F2Bs, and for F3s are September 00. Still F4s are still 99, but still F1s are in December 2000. So we will see how slow these numbers move now. But for our folks on DV 2020, I'm looking at there was actually a pretty big jump month to month. They're up to 13,000 in Africa, 6 in Asia, 10,000 in Europe, and all the way up to 6 in the Bahamas. So that means everybody in the Bahamas can apply. That one can apply for their green card. Even South America is up to 900. So that's pretty good movement in those countries. So
let me just, because I'm getting emails about this too. Let me just kind of reiterate what Chuck's saying about what the change in the rescission of the tiered priorities means for potential litigation. So if people remember right, in Go, there were 2 real challenges to the Department of State policy. First was, hey, you illegally stopped processing of all these visas during the presidential proclamation 10014 for 5 months of the year, and really for like 7 months of the year by the time they ramped up after rescission. And then after that, you didn't try to make up for lost time. Instead, you relegated them to tier 4 arbitrarily. So both of those theories, which we won on, are now gone, right? Moving forward. And so to litigate these cases, if we see that they're going slowly, if we see that DV 2022 is going slowly, in a few months, it's going to take a different legal theory, and frankly, it's going to be more challenging. Now, I don't think any of us have really spent a lot of time studying it or researching, so I don't want to say one way or the other whether it's possible, but it would be different.
Maybe Congress will solve this problem for us.
Well, that would be. Let's talk about that for a second, Greg. Why don't you give us an update on what's going on in Congress?
Well, we have a bill that has passed the U.S. House of Representatives, so we actually have the language that's passed one House of Congress, the easy house, I guess, and that wasn't so easy to get that language in there. But that bill has 2 major sections to it, immigration-wise. One is a section that creates a parole program that will allow, I don't know, I've heard of 7 million as the figure that
6.5 to 7 million people.
Yeah, that would be able to file for parole and be able to get work cards and advanced parole travel documents. That was the third version of different proposals. The original one was just a broad legalization path to citizenship program. The second one was similar in terms of changing what's called the registry date, which says that anybody who was here before a certain date just gets to go to the front, gets to get a green card. That's always been in the law, by the way. It's just they change the dates every couple of, maybe once a generation.
Every 50 years, apparently.
Yeah, well, 80. I think they changed it in 80.
86.
86
is the last time they changed it. And Greg, that's 45 years ago. 35 years ago. 35 years. Don't age us too fast.
And they anyway. So and I'll get to in a second why this parole process is. Look, it's basically DACA for everybody. I think is the way to think about it in terms of sort of how it would operate. It's a broad legalization, not a legalization program, because I guess in parole you don't actually get any kind of status or anything like that, but you do have a work card and you do have travel documents, and there might be ways that people can get on a path to permanent residency or citizenship through regular channels. So if they're eligible, but potentially for a green card, and the main reason they can't get it is because they are subject to one of the 3 or 10 year bars, or some other ways. There might be ways that we can put people on a path to getting a green card. So that's one very important part. And the other part that I know a lot of people that participate in these calls care about are the backlog reduction sections of the bill. And there are a couple of them. The first one is a broad recapture of green cards from 1990 on. And that's basically any green cards that didn't get used, like this past year, for example, where a lot of them didn't get used, would be made available again in the categories that they were originally lost, is the way I read it. So
yes, there's no more
members, right? So it's not the crossover stuff, but it'll probably be a good 200,000 or so for employment-based, 150, 200,000, and then maybe 300,000 to 400,000 I've heard potentially on the family side on there. So it will have dramatic effects on the visa bulletin if it doesn't make a lot of categories that are backlogged for years and years current. I'd be surprised, but it will. That section alone will have a pretty significant impact on backlogs. Then there are a couple of other, I think, pretty cool provisions in there that would be, really keep my fingers crossed that they end up in. One is it would allow people to file adjustment of status applications without a visa number being immediately available. There will be a supplemental fee. I think it's $1,500. You pay that
for each derivative.
What's that?
Plus $250 for each derivative.
Yeah, I think that's pretty reasonable for kids and spouses.
Oh, yeah.
So I think people will be able to, will consider that a fair fee. And that will allow them to, that does a lot of things. First of all, once you file an adjustment of status application, you don't have to deal with consulates anymore at that point, because you can get work cards, even though that's a different issue. And as far as speed goes, and you'll be able to get advanced parole documents and all that kind of thing. Plus you have portability, which I think for a lot of people, is going to be life-changing, where they would, after 6 months after they file, they would be able to change employers fairly easily, as long as they stay in the same field, or even open up their own businesses. And that's something for a lot of people that, their dreams of being a business owner have been deferred forever, basically, because of these backlogs. And they will have that opportunity as long as they start a business in their field on there. You can't just go out and do something completely different. So that's, but you can even get around that issue, because the next section is one that allows you to bypass green card caps altogether if you pay a tax on there. And it's not cheap. It's $5,000, I think, for the employment categories. I think it's $2,500 in the family categories.
$2,500 for family, $5,000 for employment.
Yeah, and
per person.
50,000 for EB5, but that's if that program comes back. So I'm doubting too many people take advantage of that, but you never know. But that 5,000 may seem like a pretty reasonable deal in order to be to just end this whole nightmare that people have had and get their green cards and move on. But it may not matter. You may not need to pay that fee if this green card recapture language really advances things pretty far along. You may decide, it's I already have a priority date. It's a couple of years old. It's not worth it to me because I'll probably be current relatively soon, or not. And you can you can kind of monitor and see how things are going. It's a 10-year program, I believe, that they've set it up for. So you don't have to make any immediate decisions.
And it wouldn't take effect until 6 months after date of enactment, or May 1, 2022.
And then there's this one last thing, which is, I guess, because this is a budget bill, and so now is a good time to switch over to this issue. But there's a supplemental fee that everybody's going to have to pay on there, and I forget what those numbers are, but
it's $100 for family-based cases.
It's like $800 for employment,
and it's like $800 for employment-based cases, and $15,000 for EB5. Let's suck it to the rich.
Screw you to the EB5s.
Yeah, maybe Cinema will object to that. I don't really know.
But anyway, so that's what the bill does. Now it's going off to the Senate now.
But wait a second, Greg, you forgot one thing.
What?
The $2.8 billion to USCIS to get caught up.
Oh yeah. I mean, $2.8 billion.
To get
I can think of about 2.8 billion ways that they could waste that money.
That's at least 2 consulting contracts for them. Now, before you go,
we will not have them whining that they don't have money.
No. Now, before you go to the politics, I want to just mention about diversity visas, because there's
I forgot about that.
There's specific rules that apply to them. So if you were denied between 17 and 21 because of the Muslim ban. Now, this means you were denied. That means you submitted the application and were interviewed and denied. It doesn't mean, hey, I'm Iranian and I get a visa. That's not how this works. All right. So it's because they're not waiving the 55,000 cap. So there's going to be a limit to how many people might be eligible for that were ultimately denied. And that's for the presidential proclamation. And then the other part is if you were refused a visa or prevented from entering the country because of the other Trump bans that were in place, then you can. But again, you had to have the visa. And then last, if you had submitted a DS-260 to the KCC, those numbers are going to come back, okay, for you. But if you did not submit a DS-260, you're SOL. All right.
Chuck, I mean, I guess is one way to think of this is that basically they're just going to reopen each year's lottery for the DV program and finish up using the numbers as if the fiscal year never ended.
Right, but only for people that submitted the DS-260s or presumably adjustment.
Right. No, I get that, but I mean, I guess that for and those are the people that are probably for most of those people thought they were probably getting a green card, so they probably did file that application on there. I think there's probably a group that just wasn't like there is every year, regardless, that just decides not to pursue it.
Yeah.
But that's the way I think is to think about it. If you were in DV 2020. What would happen is that Gomez would essentially be mooted out, I guess, because
our problem with the visas are gone.
Right. So what would happen is the State Department would just say, we still have 30,000, 40, whatever the number is, that we still have 30,000 numbers of visas that were not issued, and we are going to reopen processing as if the fiscal year never ended. For that, and just keep going until we use up the numbers for that year, and do that for each year.
But the question then becomes, for a go, I don't think that overrules go. I still think that they still have to give our go plaintiffs the visas, and then other people that don't get the visas then would also be able to access visas.
Well, here's the thing.
I'm not sure how the judge is going to view it, Chuck. I mean, the judge could change his order depending on what Congress.
No, I'm previewing my argument.
With Chuck, remember, the go orders require more than the issuance of visas. They require them done by a certain date. Mm-hmm. As I understand it, the reconciliation bill is not going to require that all of this be done by the end of this fiscal year. So, because Judge Mehta found that these cases were not only unlawfully withheld, but unreasonably delayed. So we can't just say it's moot because they're going to issue more visas in the next few years. It's already been unreasonably delayed. So,
I think Gomez is different for that reason. Gomez is a different issue. But here's the deal. This is not a prospective part of the bill, whereas the family and employment-based ones are prospective recaptures going forward. Diversity is not. This is a one-shot deal for diversity, which means the DV 2022 is still a use it or lose it by September 30th kind of situation. So, Greg, thanks for letting me devolve on that.
Let me just wrap up and explain what's happening now. So this bill, because it's already passed in the House and it's off to the Senate, the parliamentarian, a lot of people saying, it's like, what if Durbin doesn't submit this or doesn't submit that? That's all irrelevant, basically, at this point, because the parliamentarian is going to do a review of the bill that passed in the House already on there. I guess they call it the bird bath or whatever they
something like that, a bird bath. I still don't
stupid name
understand why, but
here but they basically they'll do this review, and the parliamentarian is going to do what the parliamentarian is going to do. She's either going to she could bless some of it, bless none of it, bless all of it. We don't know. I do think we'll get some word from her. My guess is probably shortly after Thanksgiving. I wouldn't expect anything this week. Although if you were going to issue a controversial decision one way or the other, Friday, yeah, Friday is the day that you do that. So the Senate basically is going to, I think the one thing that people are never really clear on is like, well, what does it mean if the parliamentarian, obviously if the parliamentarian blesses it, then we're off to the races and we can just focus on just getting the overall reconciliation bill passed. No sure bet either, because there's a lot of, there's a lot riding on one senator who at this point, I don't know how many, electric car plants or whatever they can put in his state to make him happy, but he's got he's got to make some kind of decision on the overall bill. But what would happen is that, if she says no, their options are strip out the language, which actually has a budget, has an impact on the overall numbers as well, and that could affect the overall decision making. They could strip it out. And they could risk that bill not passing in the House when it goes back, because what did they have, like a 3-vote margin? It was really
well, I will tell you, there are at least 3 Democrats who will not vote on the
bill. So that's a troubling option for a few for the Democrats, is to not have any immigration in there. But they may decide that the president may just do a lot of crying on the phone and get these people to change their mind. We will see. The other option they could do is they could alter the immigration provisions depending on what the parliamentarian says. If she says part of it's okay, and we'll see on that. That's not really clear. Senator Menendez, I know for one, had expressed some reluctance to leave out that first part, for example, a parole option. If she says that's where the problem language, it could be that she says the green card language is the problem language. She had problems with green card provisions, and the first two times at bat.
But we do know that visa recapture was previously in a reconciliation bill in 2000.
We know, although I don't know how much she feels bound by previous decisions on that. And then the other option that they could do, which a lot of people are kind of discounting, but I wouldn't be, so sure, is that they could basically just ignore the parliamentarian and keep the language that's in there. Now, what would happen is that there will be a motion that's made. I forget the name of the motion, but there's a motion that's made objecting essentially to language in the and having that it needs to be stripped out because it doesn't comply with the reconciliation rules, which are basically that the bill is primarily budget. Its purposes are budget more than policy. I don't really understand that, because most of the stuff in this bill that has nothing to do with immigration is about policy. All the environmental stuff, for example, is not just to raise money; it's to clean up the earth on there. So, but if they have to come up with 60 votes in order to strip out language that's already in there. So it's, the Joe Manchin or whoever has a problem with it on the Democrat side, I doubt the Democrats will lose 10 votes, in their caucus if it came up for a motion. They might lose like 3 or 4 on there. And then the question is, okay, so this language stayed in there over Manchin's vote. Is this enough for Joe Manchin to kill the whole bill at the end, take it or not? And I'd like to think that probably if he gets to vote no on that issue, he can then say, at the end of the day, I made my opinion known on that, but the bill is overall had too many other things I thought were important. And he says it's more a process than a substance issue as far as why he has problems with it. He's generally okay with the immigration language. It's not
no problem on the immigration language. And Sinema says she supports the immigration language, although
so I think she's good on this issue. I think it just comes down to Manchin and whether this would cause him to change his final vote on the bill. And I would presume Schumer and Durbin and Pelosi know already.
Pelosi apparently has been communicating directly with Manchin, according to that great article the other day that came out.
Yeah, I think they know so I don't think they're going to just kind of roll the dice. I think if they actually try and take that maneuver with having, and with keeping the language in there on the House side, then they will. We already know that it's not going to affect the final vote.
Everybody knows this language is Plan C minus whatever. I refer to this as Plan Previously Licked Lollipop. Nobody likes the plan. Especially for those that have been waiting patiently for a real fix to our immigration, because none of this fixes our immigration system. There's no substantive change except for adjustments to our immigration system. Still have permanent bars.
The only way immigration is going to get fixed, in my opinion, like the real fix, is if the Democrats have 54 or 55 votes.
That's exactly right. That's it. That's all it's going to be.
And a lot of people right now are thinking the Democrats for sure are going to lose seats next year. We just don't know. It's a year off. A lot of things can happen in a year. Trump can be indicted. The economy.
Did you say Trump got indicted?
The inflation stuff could be a distant memory. All the things right now. This is what I love about sort of a punditry in elections. Year out, they will pronounce that they know exactly what's going to happen in a year. I mean, can you think of anybody who would have seen COVID coming, in November 1919? Right, but in November 2019, excuse me, not 1919, November 2019, you had a lot of people that just were making all kinds of predictions about what was going to happen based on what was going on in November 2019, what was going to happen the following year, and nobody had any clue.
Nobody predicted Joe Biden as president. I can tell you that in November 2019.
Yeah, so a year is a long time, and so the Democrats could actually. There are a lot of Republican seats up. There's some encouraging news regarding states where the Republicans were supposed to be competitive that have nominated wackos. Or the people that they were expecting to run. Georgia's one that will probably nominate a wacko. New Hampshire's one that had a great candidate for the Republicans who decided not to run for Senate, Chris Sununu. I think he might be having his eyes on the White House on there. So we don't know. And, so I'm not one of the folks that says this is the last chance that the Democrats are going to have for, another decade to work on this stuff. But this is a really Chuck. I think that this is you're falling victim to the same thing the Democrats are do in general with when they're arguing over whether getting a $2.5 trillion infrastructure bill was a or $2 trillion infrastructure bill was a loss because there wasn't 2.5 trillion on there. It's like.
No, I'm just saying there are people that are upset about,
It is a massively good immigration.
No, and there's no doubt that
millions of people. It doesn't solve everything. Yes, it does make life a hell of a lot better for a lot of people.
Yeah, and keep in mind, of the 6.5, 7 million people that would be eligible, half of them are going to be able to get green cards. And these are people who have been here a decade. Many of them have kids. If you have a parole in place, you have a work card, your kid turns 21, you get a green card. I mean, that's going to happen. 1 million people will get green cards. We'll clear out a lot of the backlog. Overall, it's certainly better than nothing, but it's not nearly as good as it could have been. All right, let's move on real quick.
What else are we going to talk about?
We have no updates from any of the judges on any of the K-1 cases at all. I mean, we submitted updates to each of the cases. I think we did dismiss the Cairo case, didn't we, Aaron? So the Cairo case dismissed.
That got finished.
Because everybody got taken care of. We got mooted out. But and we know lots of people still getting their visas in the K-1s. But I cannot explain to you why so many motions to dismiss are pending. We have a similar thing happening in our H-1B lottery abuse case, where we've motion to dismiss pending for a couple months and we don't have any decision. I think the problem is all of the insurrection cases in Washington, D.C. All of these D.C. judges are up to their eyeballs in criminal cases that they did. And every one of those cases is a slog. Everybody's got to put their show on. Everybody's got to be on national TV because, they put their foot on Nancy's desk or whatever. So I think that has to do with it. But I don't. Other than that, I don't have any of the real explanation for what's going on. Let's take a look at some questions. We don't have a lot today, so we're going to ask a couple here. Grumarco is back, and I think we already answered that. Thank you. We also answered the Go question.
They might be actually, that question popped up when I was talking about the new suit, the fee suit. So it might be a question about whether Go plaintiffs would be eligible for the fee suit.
That's a good question. We have not thought about that.
Well, I mean, we've largely been thinking about it in terms of non-immigrant applicants. I guess immigrant visa applicants would be the same issue.
The only thing is, I think it would be people who are not going to go forward with their case, that know that they're not going to get a visa or know that they don't want a visa, one of the two.
Yeah.
We'll have to think about that. The Go case, I think they're asking here is the government going to appeal?
They have till the 29th, and I'm getting a lot of questions about when will they start issuing visas, the reserved visas. We don't know. Same update as last time. They asked for information about plaintiffs so that they could prepare to implement the order. We gave it to them, and that's the latest we know. They've switched attorneys on the case, along with a bunch of other cases, because the previous attorney for the government, Joe Carilli, is leaving the Department of Justice, it sounds like. Is that right, Chuck?
That's what it sounded like to me, yes.
Or maybe he's getting another role there. I don't know. But so they've changed attorneys that are entered on the case. I don't know if that means that they're preparing a notice of appeal or not. We have to wait and see.
On the Rye case, I followed this on the Twitter machine while I was in Peru, and Curtis has kindly copied us on some emails between the government. The government's formed a work group because apparently their IT system supposedly does not let them issue visas for DV category from a previous year. Literally, physically doesn't let them do that, and they have to have a work group to figure this out. Isn't that like one dude on an H-1B for an evening? I mean, how long could that possibly take? A work group. So we've been telling you guys, we didn't think they would issue any until January. Anyway, I mean, so no, I don't think they're going to issue any Go visas before then. Let's see. Your lawyers, many thanks for your efforts. Can you please tell us, Gomez, again, we don't, that's probably January if they don't appeal. Jason, I will have a great Thanksgiving. I am currently thawing our 22-pound turkey and getting it ready for the deep fryer. If you've never had fried turkey, you should come to the South, baby, because fried turkey
everything is fried in the South.
Man, fried turkey, and you got to live for fried turkey. It's the best way to go. Let's see, diversity visa. I don't know what that means, any changes. Oh, Greg, we already talked about these kind of changes in the bill. With me is Judge Gomez be holding off purposely allowing the case to fix itself. Oh, he's talking about asking the judge to clarify. Now, I will tell you on the clarification request that we filed, the government opposed it and said, hey, you didn't consult us first, which is not true. We, in fact, did consult them. And in fact, we did say that in our filing. We didn't file a reply brief because it really wasn't necessary. And we'll see what the judge does. I mean, the reality is this legislation fixes that, because this legislation lets you come in on your visa, period. We wouldn't need an order from a judge And frankly, you may get the legislation passed before the judge gets around to the case.
Some of the judges might be thinking that.
Yeah. So unless we've already talked, Greg, Aaron, and I already talked. We don't think the case is moot if it goes forward. So, that's it for today. We've got it's been a kind of a casual, fun day. We'll be back next Tuesday but we'll be way bigger because we will be eating all this turkey and mashed potatoes and stuff.
The turkey trot.
What's your pie of choice?
My pie of choice is blueberry.
Ooh.
I'm a blueberry guy. I love blueberry pie. My wife is banana cream.
Banana cream. I was just gonna say my uncle makes an unreal banana cream pie.
We did just bring in our Meyer lemon tree, which we of course can't grow outside here, but you can grow in the wintertime. And all the lemons are now getting ripe. They actually made enough lemons ripe by tomorrow to make a Meyer lemon pie.
That sounds good.
Awesome. And of course, your favorite side dish, my favorite Thanksgiving side dish is stuffed mushrooms. I love stuffed mushrooms.
Just mashed potatoes.
Oh, you're mashed potato. Yeah, I'm more of I love stuffed mushrooms. I can eat those things all day long. Greg's going, I'm not eating. You can stuff mushrooms with.
I'll eat tomorrow. Yeah, no, I will. I mean,
you have like a big piece of tofu in the shape of a turkey. I mean,
no, vegetarians on Thanksgiving just live off the sides.
Oh well,
that's good. That's the best. The turkey's not that good anyway.
Well, because you're not frying it.
True. I don't want to blow up the neighborhood.
It only happens if you put a frozen turkey in the oil. All right, everybody. Have a wonderful day. We'll see you guys next Tuesday.